Good morning and welcome to this joint committee hearing of the Hawaii State Senate Committees on Commerce and Consumer Protection and Judiciary Committee. This is room 016. I'm Senator Jarrett Kehokalole, chair of the CPN committee. I'm joined by all the members of the committee, Vice Chair Senator Fukunaga, Senator McKelvey, Senator Richards, and Senator Awa.
And for the judiciary, everyone's here except for Senator Sanguine Ventura, who's excused. Thank you.
Okay, just a quick note, this meeting is being live streamed on YouTube, and in the unlikely event we need to abruptly end this hearing due to technical difficulties, we will reconvene on Thursday, March 2nd at 9:30 a.m. and a notice will be posted on the legislature's website. We have one regular agenda where we will be taking testimony, followed by two agendas where we will be making decisions on bills. In the CPN committee, we have a 2-minute testimony limit. We've already received your written remarks and reviewed them, so feel free to stand on your testimony if you choose to. First measure on the agenda is SB 26 relating to the Landlord-Tenant Code. This measure prohibits landlords from recovering possession of a dwelling unit from tenants if habitability of the premises is significantly impaired. First up, we have the DCC Office of Consumer Protection and Support.
Good morning, chairs, vice chairs, and members of your committees. Mana Moriarty, I'm the Executive Director of the Office of Consumer Protection. I'm going to limit my remarks to the subject of my testimony, which was that the minimum amount of damages should be established at law to provide a significant incentive for landlords to comply with the provisions that already exist. There are already provisions at law that provide that retaliatory evictions are not permissible. I don't understand the testimony from the Realtors Association, which highlights these existing provisions. Yes, they exist, but this measure, as we can see from the findings, the carefully drafted findings in the bill, is intended to incentivize the landlords to comply with these provisions. So our testimony was to the effect that a damages minimum is appropriate in these situations where a retaliatory eviction is established. And we agree with the finding that the burden should not be on the tenant to prove the entitlement to damages. That may require access to expert testimony, which they simply do not have the means to get. And in addition, we offered the amendment that the minimum damages should be at a level not less than 2 months' rent. Happy to answer any questions from the committee, and thank you for the opportunity to testify.
Thank you very much, Mr. Moriarty. Next, we have the Hawaii Realtors in opposition. Good morning. Thank you for standing on your testimony. We also have DHS Director offering comments and Will Karen in support. Is there anyone else who would like to testify on this measure? Seeing none, members, questions? Vice Chair.
Okay, one follow-up for Mr. Moriarty. In the Realtor's testimony, the concern that was raised says that tenants can unilaterally, raise this complaint that the unit is significantly impaired. Under the existing law, are there specific sort of thresholds to be established or that are already in existence that either your office or other organizations are able to verify?
I'm not sure exactly if I'm going to answer your question exactly as intended, but let me address that by saying, if the concern is that there's a unilateral assertion of a significant impairment, that doesn't strike me as an issue. In our adversary system, each party is entitled to make their assertion. This measure creates no new rights to assert a significant impairment, and the tenant will still be required to prove at a court of law that a significant impairment exists.
Okay, thank you.
Thank you.
Members, any other questions? All right, thank you very much. We'll move on to the next measure, SB 910, relating to intoxicating liquor. This measure restricts the sale of liquor under temporary liquor licenses to confined and demarcated spaces not located on public streets, roads, sidewalks, or pedestrian walkways, and applies restrictions to temporary liquor licenses granted to nonprofit organizations. We have testimony in support from Elizabeth Stack, and also testimony in support from Chulan Schubert Kwok. Is there anyone else who would like to testify on this measure? All right, seeing as there's no one to ask questions of, Chair, if it's okay with you, I'm gonna move into decision making.
Yep, sure.
Make recommendations. Okay, so for the first measure, SB 26, the recommendation is to adopt the Office of Consumer Protection amendments, setting the minimum at 2 months rent, and to defect the effective date to July 1, 2050. There are also some technical, non-substantive amendments. Members, any discussion? Okay, seeing none, Vice Chair, SB 26 passing with amendments. Chair votes aye.
Thank you. Vice Chair votes aye. Senator McKelvey.
Yes.
Senator Richards.
Reservations?
Okay. Senator Owen.
No.
Okay, measure is adopted.
Okay, for judiciary members, same recommendation with amendments. Questions or concerns? If not, Vice Chair.
Recommendation SB 26 is with amendments for JDC. Chair Rhodes.
Aye.
Vice Chair votes aye. Senator Elefante.
Aye.
Senator San Buenaventura. Excused. Senator Owa.
No.
The measure passes.
Thank you very much. Next measure is SB 910 relating to intoxicating liquor. The recommendation on this measure is to pass this with amendments. We will defect the effective date to July 1, 2050 to encourage further discussion. Members, any questions or comments?
Just quick comment, Chair. I appreciate the author working on this. However, I have concerns that the Neighbor Island Commissions haven't weighed in on it. It affects more than just Chinatown, which I think the problem is trying to be addressed. So I understand it's a work in progress, but because of these concerns, I'll be going with reservations for now.
Thank you, members. Any other discussion? Okay, seeing none, Vice Chair, SB 910 passing with amendments. Chair votes aye.
Thank you. Vice Chair votes aye. Senator McKelvey.
WR, please.
Okay, Senator Richards.
Reservations?
Senator Owen.
Aye.
Okay, measure is adopted.
For JDC members, same recommendation. Questions or concerns? If not, Vice Chair with amendments.
Okay, for JDC, if the members present, are there any no votes?
With reservations.
Reservations for Senator Elefante. And then the measure passes.
Thank you.
Thank you very much. We're adjourned on this 9:30 a.m. agenda. Okay. Okay, good morning and welcome to this 9:35 a.m. Joint Committee decision-making hearing between the Hawaii State Senate Committees on Consumer Protection, Commerce and Consumer Protection, and Judiciary. In the event that we need to abruptly end the hearing and reconvene, that reconvene date will be March 2nd, 9:30 a.m. We have two measures on this decision, three measures, I'm sorry, on this decision-making agenda. The first is SB 798 SD1 relating to time sharing. This measure clarifies that a developer is responsible for ensuring that the use of out-of-state timeshare units for timesharing purposes complies with zoning and land use laws and rules of the jurisdiction where the timeshare units are located, but is not required to submit evidence of such compliance to register in Hawaii. There's also a defective date on this measure. The recommendation, after reviewing the testimony and noting the defective effective date, is to pass this measure out unamended. Members, any discussion? Okay, seeing none, Vice Chair, passing unamended. Chair votes aye.
Thank you. Vice Chair votes aye. Senator McKelvey.
Yes.
Senator Richards.
Aye.
Senator Owen.
Aye.
Measure is adopted.
Okay, for JDC members, same recommendation. Questions or concerns? As is.
For JDC, Chair Rhodes.
Aye.
Vice Chair votes aye. Senator Elefante.
Aye.
Senator San Buenaventura. Excused. Senator Owa.
Aye.
The measure passes.
Thank you.
Thank you very much. Next measure is SB 1378 SD1 relating to unlicensed care homes. This measure clarifies that any person, corporation, or entity is prohibited from knowingly referring or transferring patients to an uncertified or unlicensed care facility, and also repeals the landlord exclusion. After reviewing the testimony, the recommendation is to pass this measure unamended. Members, any discussion? Okay, seeing none, Vice Chair, SB 1378 SD1 passing as is. Chair votes aye.
Thank you. Vice Chair votes aye. Senator McKelvey.
Yes.
Senator Richards.
Aye.
Senator Owa.
Aye.
Measure is adopted.
Same recommendation for JDC. Questions or concerns? If not, Vice Chair.
For JDC, the chair votes.
Aye.
Vice chair votes aye. Senator Elefante.
Aye.
Senator San Buenaventura is excused. Senator Owa.
Aye.
Measure passes.
Thank you very much. The final measure on this decision-making agenda is SB 478 SD1 relating to telecommunications and cable industry information reporting. This measure essentially repeals Chapter 440J of the Hawaii Revised Statutes relating to telecommunications and cable industry information reporting requirements for broadband. The recommendation, there's also a defective effective date on this measure. So after reviewing the testimony, the recommendation is to pass this measure out with technical amendments. Members, any discussion? Okay, seeing none. Oh, Vice Chair.
Okay, I know that, the reporting requirements for broadband are basically kind of being superseded by a lot of the FCC work. However, I did review the testimony from AARP, and one area of concern that I don't think is necessarily addressed at the FCC level is the resolution of complaints. So I'm going to be voting with reservations. It's just to kind of identify areas where we want to make sure that at the state level we do have specific avenues for resolution of consumer issues and concerns. Thank you.
Chair, I'll be doing the same with the same reasons indicated by the vice chair.
Okay.
I agree. I'll be doing the same.
Thank you for that. I will note the concern and also point out that there are some other additional issues that I think merit further discussion, especially considering the fact that the cable division in the DCCA really does not have the regulatory authority over broadband that it once did over cable operators.
Right.
So your concerns are noted. But I do think we should keep the conversation going.
I disagree.
Okay, so noting the concern, Vice Chair voting on SB 478 SD1, passing with amendments. Chair votes aye.
Thank you. Vice Chair votes with reservations. Senator McKelvey.
WR.
Senator Richards.
Reservations?
And Senator Owa.
No.
A measure is adopted.
Okay, for JDC members, same recommendation with amendments. Questions or concerns? If not, Vice Chair.
Chair Rhodes.
Aye.
Vice chair votes aye. Senator Elefante.
Aye.
Senator San Buenaventura.
Aye.
Senator Owa.
No.
The measure passes.
Thank you very much. We're adjourned on the agenda. Okay, we're convening this 9:36 a.m. decision-making joint agenda between the Hawaii State Senate, CPN and JDC committees to take up SB 793 relating to recycling. This measure amends recycling goals under the Electronic Device Recycling and Recovery Act so that goals are based upon the manufacturer's overall market share in the state. The measure also amends penalties and definitions. Members, after conferring with the JDC chair and reviewing the testimony, including some of the proposed changes, at this point, the recommendation is going to be to defer. There are just too many moving parts on this measure, and we just passed the last law. Any discussion? Chair. Senator Richards.
Thank you. That was my concern in discussing Big Island people and the environmental management, Ramsey Mansour. We have a law 151, I believe, in place, and they said give it a little bit of time because it's actually starting to work, but we got to give it time to see how it sorts out. So I would have been voting with reservations or against, but I appreciate it. Thank you, Chair.
And so I would just say I concur with the reasoning and the deferral.
Okay. If there are no other comments or concerns, we're adjourned. Thank you very much.
It's the 10 o'clock decision-making only agenda for JDC on SB 40 relating to discrimination. Would establish provisions relating to civil remedies for discriminatory reporting to a law enforcement officer. Provides that a person who summons or reports to a law enforcement officer without reason to suspect a crime has occurred because of that person's belief or perception involving a person of a protected class shall be civilly liable. Recommendation here is to pass with amendments using other jurisdictions' laws as models. Will amend the proposed discriminatory reporting law to reporting to law enforcement to add the state of mind of knowingly, prohibit causing a law enforcement officer to come to a location to contact a person on the basis of the person's actual perceived race, color, ancestry, ethnicity, national origin, place of birth, sex, age, religion, disability, sexual orientation, or gender identity, with the specific intent, this is what you couldn't do, with the specific intent to infringe upon the person's constitutional rights, discriminate against the person, cause the person to feel harassed, humiliated, or embarrassed, cause the person to be expelled from the place in which the person is lawfully located, damage the person's reputation or standing within the community, or damage the person's financial, economic, consumer, or business prospects or interests. Will add a minimum amount of damages to be awarded of at least $1,000 plus attorney's fees and costs, and specifically authorized punitive damages. Will require the Department of the Attorney General, in consultation with the Hawaii Civil Rights Commission, to provide guidance on the law and have the Department of Law Enforcement take on the task starting in 2024. And that's it. So the bottom line is, it would make it so you're civilly liable. I'm sorry, is it civil or is this I can't remember. Civil. It's civil. Okay. Civilly liable if there's a Micronesian in the park, please bring the police. That's what we're trying to avoid here. Mm-hmm. So I think that the hoops that you have to jump through to prove it are strong enough that it'll be hard to abuse, and that's why I'm recommending in that way. Questions or concerns? Yeah.
So there is already a crime called false reporting. I guess in the committee report, maybe a prima facie case can be made if somebody is already convicted of false reporting.
Okay, I can mention that in committee report that if the false report, yeah, okay.
If there's already a crime.
Yeah, it's already a crime.
Someone's already
I don't know.
That way you don't have to go through all the hoops because they've already been convicted of false reporting.
No, if the elements overlap. If it's all right, we'll just note it, that there's a possibility of a connection there, but I'm not sure the elements are close enough. Okay?
Okay, thank you.
Other concerns? If not, Vice Chair.
Okay, the recommendation is to pass SB 40 with amendments. And the members present, are there any no votes or reservations? Hearing none, the measure passes.
Okay, thanks very much. We're done.